I've set myself a challenge this morning after you've sat in here for an hour in this warm, cozy room listening to presentations. That is to keep you awake, because my presentation is the least sexy one of the morning, being a lawyer, as Hans said. Let me explain who I am. I'm an environmental lawyer, and I've been working on the Fuleni matter for 2.5 years now. Can I just have a show of hands of people who know about the Fuleni matter? Okay, cool. Can I have a show of hands if anybody's here from Ubuntu Coal? Okay, good. Okay, then I can speak freely. I've tried to keep this presentation to not tell you too much about the matter itself, but to just discuss the issue of environmental justice. And strangely enough, you're going to laugh at me, but I actually only recently became aware of that term in the last year. As an environmental lawyer, I just assume environmental law, but environmental justice is quite different to environmental law itself. And the reason being is that as an environmental lawyer, you deal with environmental law, and as you work with environmental law, you become more and more aware that human rights are inextricably linked with environmental law. And that is what environmental justice essentially, very briefly, is. It's a combination of human rights law and environmental issues, but throwing in democratic accountability into the mix as well. So it's based on constitutional law, and although there are many definitions in the world, I have tried to narrow it down to just some fundamental ideas. And do I press down or arrow? Down. And these are briefly them. Essentially, environmental justice is that the people need to be involved in every level of decision making. And there needs to be fair and meaningful involvement of these people, free of race, free of bias, free of discrimination, in the implementation of these laws and in the enforcement of the laws and the policies involved. That is equality in terms of the Constitution. As well as that, we need a right to their healthy environment, but also we don't want people to have to choose between a healthy environment and earning a living. So I can either work for a mine or live on the edge of a mine or lose my livelihood. So I have to choose. I think environmental justice is protection from extraction, production that threatens the fundamental rights to clean air and land and water and food, and the right to ethical, balanced and responsible uses of land on a sustainable basis. That's the healthcare, food, water, and environmental clauses of the Constitution, Bill of Rights. So I'm constantly just going to try and bring you back to the Bill of Rights, just to show you how environmental justice is all in the Bill of Rights. Environmental justice protects the rights of victims of environmental injustice to receive compensation and reparations for damages, the right not to be deprived of property or being coerced to leave your property. I've often said that certain mining applications would be tantamount to land grabs because people are forced to leave their homes with very little compensation, if any. Environmental justice considers environmental acts of environmental injustice a violation of the Bill of Rights as set out in the Constitution of South Africa. Now, that's just administrative action and healthcare and property clauses. So are there any cases of environmental justice in South Africa that have been before the courts? Very few. In fact, in the true environmental justice sense, I would say none. Why do I say that? Because we as attorneys take matters to court on winnable points of law. So we end up narrowing the claims and using things like the Promotion of Administrative Justice Act or Promotion of Access to Information Act, or we go through the motions like we do with the environmental impact assessment process. It's administrative law. It's not constitutional law. So let's talk about Fuleni and Ubuntu Coal. Ideally, we want environmental justice cases to reflect ecological and social justice issues, meeting basic human rights, but including environmental rights connectedly, as opposed to opposing them. And historically, some of the cases that have been before the courts on environmental issues, they weigh up in human rights against environmental rights, as opposed to seeing them in a combined, holistic way. So while the Fuleni matter is environmental justice in the true integrated sense, I'm saying as the attorney on that matter, it's unlikely that we'll bring it to court in that way. Why? I'll get to that. But let me explain to you why it is integrated environmental justice in the true sense. The proposed mining activities are likely to have a significant impact on 16,000 people. It's on the border of the Shishluwi-Umfolozi Game Reserve on the southern border on the wilderness area. The mine will displace approximately 1,000 people from 7 villages. Back to the Constitution, housing and property rights being affected. The loss and pollution and depletion of fresh water resources. These people rely on the water from the Umfolozi River and the Umfolozi catchment area. By granting mining rights in an area that has no water, it will be tantamount to removing the right to water in that area. So water and security gone. The removal of land used for subsistence or communal farming threatens food security. The loss of access to communal resources such as firewood and wild plants. Social impacts associated with the influx of outside people to the mine. Increase of crime. Breakdown of traditional and cultural norms and practices. Deprivation of use and occupation rights. Loss of schools, clinics, places of worship. The need to move graveyards. Social security, Bill of Rights. Never mind the severe impacts of health and the emotional well-being on the people living in the area, those that don't get moved very far away, associated with coal dust, noise, and stress, the right to a healthy environment of the Bill of Rights. So far, the application process by Ubuntu Coal and the EIA process, both in terms of the EIA and the mining rights application process, they have lacked due process and regard to the law. They've lacked transparency. The involvement by the community has been scarce, both in the proposed project. People that people haven't been told that they have to move out of the way. We've found that out and told them. In the decision making, in the ability to say what they want to say without being threatened, this is affecting equality and a just administrative action. So if the Constitution is the supreme law, all law or conduct that is inconsistent with it is invalid, and the obligations imposed by the Constitution must be fulfilled. And that is consistent with what I've said my understanding of environmental justice is. So the people of Fuleni can argue that their rights, as set out in the Bill of Rights, will be, and already have been, unjustifiably infringed. So they deserve environmental justice, just like many, many other communities in mining-affected areas deserve environmental justice. But in spite of the strength in our constitutional arguments and my explanation of how the Bill of Rights and environmental justice and environmental law all work together, we continue to fight these cases on the basis of administrative law. Why? Because they tried and tested, and we want to win. So we object to the EIA process, and we object to the mining rights application process, and we follow the administrative law process. What would be really great is if we could just skip that whole section and go straight to the Constitutional Law Court and ask them to decide the matter on constitutional issues, on environmental justice issues, and set a precedent and new law in the process. I've spoken quickly because I know there are going to be lots of questions. So I thank you very much for listening. And if you want the full paper, it is on my website, and more information about Ubuntu Coal versus Fuleni, actually Fuleni versus Ubuntu Coal, is on our Save Our Wilderness website. Thank you.
Thank you, Kirsten.